Welcome to Covered, the insurance law podcast for corporate policyholders. And here we are back from our hiatus with part 2 of our episode on insurance procurement requirements. Suzanne Day, welcome back. Good to see you.
Delighted to be here, Vince.
And by good to see you, I probably see you 25 times a day in an average day, sometimes more, sometimes less, but still always nice to see you. So we just finished our return episode. We talked about some insurance procurement requirement issues because we see these in contracts all the time for our clients. But there's more to talk about, right? So we talked about the last one of kind of make sure your language is updated, make sure you have a functional template for your business. Do you use a third party to either fill out the contracts or track the certificates of insurance? There are third parties that audit additional insured requirements too. And do you want to have a specific form, right? And you know, what kind of coverages do you want to put in there? And so we talked about some of those things. But I think a couple, maybe we pick up with, you know, one thing that's really important here is to get broker input, right? These aren't really legal questions. You know, what insurances to buy, what limits to buy. Those are broker questions, not legal ones, right? We can help clients think through, you know, if you have a loss, what might the liability exposure look like? That's a legal question. We can assess that. But a lot of these things based on what's available in the marketplace on commercially reasonable terms, those are broker questions, not legal ones. And so I think one of the things that we always do is we ask our clients, who's your broker? Let's get them into this conversation. You'll end up better off on the back end if we kind of look at this from all the different angles. Do you have, you know, I know in your role at Lubrizol, where you were the general counsel, chief legal officer, you were also the risk manager. Did you know, kind of straddle in those two worlds with law and risk management? Did you have any thoughts about that, you know, going back to, you know, your prior role there?
Well, it's true, Vince, that at the end of the day, when you are requiring your counterparty to purchase specific forms of insurance, that is part of their fixed cost, which in some form or fashion is going to be passed along to you. So getting broker input about whether what you're asking for is something that the counterparty likely already has and therefore is likely already priced into what they're selling you, or whether what you're asking for is something that they would, if they want to do business with you, have to incur additional expense to procure, and therefore probably your price is going to go up. That can really give you very good practical advice about what kinds of things you want to ask for. It doesn't necessarily mean you don't ask for something that you think you need, even if the counterparty doesn't already have it or isn't likely to already have it. But you should always keep in mind that when you are requiring somebody else to do something, they're often going to come back with an additional charge to you. So that is really part of the equation that brokers can be quite helpful with.
Yeah, thanks, Suzanne. And I think this is one of the things where it's really important. In a perfect world, you'd have and not every client has their organization, you know, sort of staffed down or dedicated in this way, but you want to have the people that are responsible for these decisions, both inside the company from a legal standpoint and a risk management standpoint, and then their outside advisors, you know, their lawyers, their risk, you know, their brokers, that kind of stuff. Sometimes they have risk management consultants. They want to make sure that, you know, that everybody that needs to weigh in on this stuff does. And I think that's really important. All right. One of the other things that we constantly get asked about is, well, what limits should I put in here? And that again is more of a broker question than a legal one. But the other part of that question, and this is going to be something I'm really excited, really glad to have you. I'm glad to have you part of our team with the experience you have, you know, from your role at Lubrizol and all that kind of stuff, and bring those resources to our work. But one of the things that we see clients ask about, and this is going to be a little preview for our listeners, is going to be a future podcast on wording that people skip over. But, you know, there's that, you know, you want to have say it has a requirement for a CGL policy. And some people say, you know, I want 1 million, 5 million, 10 million, whatever. And we know that that's probably a $1 million primary layer with an excess or an umbrella policy to, you know, get to the number there. But the wording that I think a lot of people don't focus on until there's actually an accident is what comes in front of that dollar amount, right? Is it not less than? Is it at least? Is it, or just you will get limits of? And I think a lot of people kind of gloss over that. And this is one of the things we're spending a lot of focus on, is trying to make sure that if you look at the rules of contract construction, it's, you know, you have to look at every word in a contract, and none are rendered, you know, meaningless or surplus or otherwise. And you can't read words into it. You can't read words out of it. And you know, do you have a thought about that issue that's worth a quick mention?
So there's a couple of things I think that spring to mind when we start talking about the limits and the modifiers of the limits that are in the contract. The first thing is you want to make sure that your risk tolerance and the limits you think you're getting match up with any deductible provisions. So for example, if you require $1 million limit and don't have any requirement at all as far as the deductible that the counterparty must have or no more than, then you can end up with no insurance at all. And you're really just relying on your counterparty because the counterparty can go out and buy $1 million policy with $1 million deductible and still comply with your insurance requirements. So that is the first thing that springs to mind when we're talking about limits. Another thing that springs to mind when talking about limits is when you're deciding what limits you want to require, some people, some companies may think about where their own insurance kicks in. And that goes back a little bit to what I was talking about before about the cost. And so if you have already priced into your business model part of your costs, for example, a GL tower that kicks in at 5 million or 10 million or 25 million, you might rationally want your counterparty to provide you with that first layer so that you would want to be an additional insured up to the point where your own insurance will kick in. So that's another way to look, or another way to figure out what number you want. But then you're right. The main question is once you've figured out the number you want and the deductible that you're able to live with, do you want to require that counterparty to give you a specific number, or do you want the not less than or the minimum requirements? And that question often becomes really real and really significant when you are talking about the additional insured endorsement, because many forms of additional insured coverage and endorsements to CGL policies will limit the entitlement of the additional insured to coverage to the amount required by the contract. And so if there's a fixed amount in the contract saying you get $5 million of insurance, even if your counterparty has 50, the insurance company will say, look, under our endorsement, it says that you only get what's required, only 5 is required. And so you get 5 and it doesn't matter that the damages are 40. We're not covering you after the 5 that's required by your contract. So some ways that people try and get around that is to use a minimum requirement. So what you're trying to do is set a floor saying, I want at least $2 million of coverage. I want all you have, all you've bought, but I want at least $2 million. And in fact, because of some of the case law that's developed in certain states, some contracts that I have seen actually take the next step to say that the limit for this particular line is going to be whatever your normal CGL tower is, or $5 million, whichever is greater. And those sorts of phrasing, that sort of wording is really trying to marry up with the endorsements that say you get only what's required by the contract. So you want to keep that in mind. If you have a counterparty or if your form doesn't require a specific endorsement for additional insurance, you really want to try and make sure that you get the policy limits if you can.
Yeah. So, and that leads us to another one, kind of the mirror image of the insurance requirements is the indemnity, right? And so one of the questions that we see from clients is, well, should we make the insurance connected to the indemnity or should we make them separate? And that's a good question, right? And there's no one size fits all answer here. Depends on, kind of what the nature of the contract is. Are there going to be statutes that impact the enforceability of the indemnity or the insurance requirements? And sometimes the indemnity is unenforceable, like under the Texas Oilfield Anti-Indemnity Act, it's unenforceable unless you back it with insurance, and then it has very specific requirements for how that works. And so that's a question to think about. And sometimes, the insurance is credit support for the indemnity, right? Sometimes we have seen instances, and I think wrongly, but some companies, they agree to these indemnity requirements and they agree to provide insurance. And their answer is, well, you have access to my insurance. You should just leave me alone on my indemnity. And that's not how it really works, right? Unless the contract says that's how it really works, right? And some contracts say that is how it works. Some say that's not how it works. Some are silent on how it works, but you gotta think through these issues. And so I think those are really good things to be thinking about. And one of the other things that we see come up in these things is what about retentions and deductibles? right? So suppose somebody has a $2 million limit, but they have $1 million deductible, right? So the insurance company isn't going to start paying until $1,000,001. But how do you think is the best way to address those things? Do you just, what's your thought about that?
Well, I think you have two options there. You can either decide that you have an acceptable risk tolerance of, $50,000, $100,000 and specify in your contract that the deductibles for the policies that your counterparty is going to buy will not exceed that. Again, that gets you back to, is that a commercially reasonable requirement? Are you going to have to pay more for that requirement? So an alternative to that, if it turns out that that does not seem the smoothest way to get what you want, the alternative to that is to say that you counterparty are going to provide this insurance, and you counterparty are going to be responsible for any retentions or deductibles that are necessary for the insured to pay prior to the insurance company's obligations to indemnify or defend kicking in. So that can be dealt with in the contract. Along those lines, you also want to think about it. I haven't seen too many contracts that actually get into these weeds, but whether for example, in a CGL policy, if you're talking about your rights as an additional insured, if somebody sues you for an injury that the other party has arguably caused, you want to think about whether your costs that the insurance company is incurring to defend you are going to erode your limits or not. Mm-hmm. Particularly if you have a low limit of $1 million and the defense costs erode that limit, you may not end up with much insurance at the end of the day to pay a claimant. And so that's another thing that you could consider when you're talking about who pays what on the defense costs, whether the policy is going to cover those and who's going to be reimbursed.
Well, I think that's a great point, because some of the lines of coverage that we see in these things have eroding limits and some don't. And it's not like it's a choice that you can lawyer through and say, or risk manage through. I mean, these are, it almost entirely depends on what kind of coverage you're dealing with. And it's kind of binary, right? I mean, the GL policies almost certainly are not eroding unless there's some wonky endorsement, which we see from time to time, but it's rare. And then the professional lines, professional liability, those kinds of things almost certainly are eroding. And so you've got to, be aware of, which one you're dealing with. And that might warrant different limits in one and different, approach to deductibles and retentions in another. And those are things to keep in mind.
Yeah, it really goes back to what you said, I think, in part one of this, which is the start of any good insurance section in a contract is for the party to sit down and think about what they want to accomplish. I would like to be defended up to this amount of money and have this much indemnity available to me. And then you can draft your insurance requirements either by making deductibles required or making certain defense arrangements required or making other sort of things into your contract that is designed to get you what you have in mind as the end game. Starting sort of from a blank slate saying, is a $5 million a good number? Doesn't really get you what you need in too many situations. Yeah,
I think that's right. So, Suzanne, let's close on one thing, because I don't know, maybe we need part 3 for this episode. There's just so many things to talk about here. But waivers of subrogation and primary non-contributory. And I think this really does come up in a lot of different ways. And I think parties need to specify, because, right, if you have two insurance, there's that California case that said the only thing worse than having no insurance policies is having two insurance policies. And the point of it was, now we got to figure out how to make these two things work together, right? And life insurance is pretty easy. You can just generally stack them on top of each other. With other kinds of insurance, they have more precise sort of mechanisms. And so I think maybe what we'll do is we'll save that, the waiver of subrogation and the primary non-contributory, we'll save that and a couple other things for maybe part 3 of this episode.
Boy, I can hardly wait.
Yeah, that's right. Well, listen, we're out of time for today, but thank you, Suzanne, for joining us again. And we've left ourselves with some homework, so we're going to work on part 3. We'll be back, listeners, with another episode of Covered coming your way soon. Thank you.